And this is actually, Ms. Eckenruddy, you are calling the complainant.
That is correct, Your Honor.
All right, very good. If she can.
Your Honor, for the record, we have an objection to that. Mrs. Burns has already testified at length. She's answered many questions. I've asked the defense for an offer of proof of what they would need to call her for after having cross-examined her for quite some time. And I'll let defense counsel speak to that. But my understanding is there may be some questions based on the testimony of other witnesses. I would ask that, well, first I have an objection to her being recalled, but if the court's inclined to recall her or allow for her recall, I'd ask that the questions be limited to whatever new information we have based on the testimony of particular witnesses, and not to rehash essentially her former testimony.
And as I had indicated, counsel, I'm not going to let the latter happen, but there were witnesses that testified after she did. My understanding, Ms. Eckenruddy, is questions are directed toward issues raised with witnesses.
Yes, Your Honor. So there are questions that I needed to ask this particular witness as follow-up based on some of the testimony that was brought out by the other witnesses. And honestly, Your Honor, there are some, in communicating with my client, there are some other questions that he wanted for me to ask this particular witness.
Your Honor, I guess if I may.
Where the opportunity has already been given.
Your Honor, that's a difficult question to answer, primarily because, that was one of the reasons that I reserved the right to recall her, because I knew that there were some points that, depending on how the remainder of the testimony came out, I may want to bring up. If there were testimony that was not able to come out from other witnesses, then she's the only person that would be able to testify to that. I may not have asked her those questions on cross immediately, or maybe there were questions that were not brought up in direct that just wouldn't work in the course of my cross that I would have to bring up again through my direct.
All right. Well, rather than go through this almost in a hypothetical, what I will do is where there's an objection, make the objection, and I'll rule as we go forth. My intent, quite frankly, is not to allow the rehashing of what she's already testified to.
Thank you, Your Honor. And the other matter I want to put on the record, we briefly discussed before we finished last time, and my understanding is we are not going to be asking questions or going into anything that was found on the defendant's phone as a result of that search warrant. During my questioning of Sergeant Matthews, I was objected to, I was stopped. We didn't get into any of that, so that would be another limitation I want to make sure we have on the record.
Second, early.
And Your Honor, I do understand that we are not going to discuss, or I do not plan on discussing anything that was a product of the search warrant from Mr. Burns' home.
Okay, very good. All right, you may call your witness.
Your Honor, defense calls Madison Burns to stand.
Just want to make sure that's. Please come forward. May I have her seen?
Please take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth. See? State and spell your first and last name for the record.
Madison Burns, ISYNBURN.
All right, you may inquire.
Thank you, Your Honor. Hi, Madison. I think you remember our last conversation. I just have a few more questions that I need to ask you, okay? Madison, I just want to take you back to, I think this was on May the 9th, when you were at the hospital at U of M. Do you recall being in a room? Your Honor, I do. I want to ask the court if it's okay that I ask cross-examination questions rather than direct. Thank you, Your Honor. You were in a room across the hall from the room where your son was being treated. Is that correct? It was around the corner. Okay. And you went into that room with a nurse? Okay. And when you went into that room with the nurse left you in the room, right, by yourself? Okay. And then after you were left in the room, the social worker came in to speak with you. Okay. But at no point you had not met that social worker previously, is that correct? Do you remember the social worker's name? And do you remember telling the social worker what had happened between you and my client, your husband, Mr. Burns? Okay. And do you recall what day you told her that incident had happened? You told her it was on May the 7th. You know, she took notes as to your conversation with her? Okay. You talked to the social worker about a safety plan. Do you recall that? You don't remember? Do you know anything about a safety plan?
And I'm gonna check if we could be a little more specific.
I'll sustain that objection because that means a lot of different
Okay,
things.
all right, that's fair. Okay, so you had told the social worker that you and my client had had sex. You're saying that you told her that it happened on the 7th. Okay. Do you know why she would have thought that it happened on the 8th? Okay. And when you told her that you and your husband had had sex on that date, do you recall anything else that you told her? Now, I want to talk to you a little bit about that date on the 10th. Do you remember you and Jerome talking about posting a photo of his vehicle on Facebook?
I'm gonna object, Your Honor. I'm not sure how this is relevant.
Your Honor, if I can just have a little bit of leeway, this leads to some of the testimony that was given by Officer Eckel. No, that's not his name. The arresting officer, Judge, I had asked him some questions in regards to statements that my client had made. Aaron.
I'll overrule the objection and let you.
Thank you, Your Honor.
Go ahead.
Okay, I didn't hear your answer to that question, Madison, I'm sorry. Do you recall you and Jerome were looking to post his vehicle on Facebook Marketplace for sale? You remember that? Okay. Okay. He wanted to post his vehicle for sale on your marketplace. Okay. So when you, and how was he going to do that? He was going to use your phone to do that. Is that right? Okay. So you had opened your phone for him to allow him to make the post? You had your Facebook on there. Okay. So while he was doing that, do you recall realizing that he saw some messages between you and someone that you were involved with? You don't remember? But you had been having a relationship with someone else, is that correct?
Don't see how-
Sustained.
Thank you.
That is a deceptively simple redirect question, but make no mistake, it's doing a lot of work. After a witness struggles through memory gaps, awkward answers, and a pretty aggressive cross, the prosecution often tries to pull the focus back to demeanor, stress, and emotional state. In plain English, they may be trying to explain to the court why this witness seemed shaky without conceding that her testimony is unreliable. It's a subtle repair move. Instead of fighting every inconsistency head-on, the attorney pivots to the human side of testimony: pressure, discomfort, fear, exhaustion. And honestly, that can be effective because a witness who appears overwhelmed may come across very differently than a witness who appears evasive.
So Madison, you're telling us today that there was, well, on that day, you don't recall giving, you didn't give my client permission to go through your messages on your phone. But you had previously indicated that my client accused you of cheating on him, right?
And I'm gonna object. We're getting into kind of old things, but also I know there was some leeway for leading questions, but now we're getting into a very a more aggressive form of it, and I don't think that's necessary to develop the testimony.
I'm going to sustain the objection and ask you to rephrase in a second.
Okay, thank you. Madison, on that day, had Jerome accused you of cheating on him? Okay. And then Madison, let me just take you back to the 7th, okay? You had previously testified that my client had been asking you over and over again to have sex. Is that right? Okay. And then when you did decide to have sex, you walked into that bathroom first, right?
I'm gonna object, Your Honor.
I'm going to sustain that.
One second, Your Honor.
Bless you. You want to get the microphone.
Thank you.
Plus you, one more time, you're on your own.
Okay, Your Honor, I do not think I have any further questions for this witness.
Any cross.
Very briefly, Your Honor. Hi, Madison. Madison,
That is a deceptively simple redirect question, but make no mistake, it's doing a lot of work. After a witness struggles through memory gaps, awkward answers, and a pretty aggressive cross, the prosecution often tries to pull the focus back to demeanor, stress, and emotional state. In plain English, they may be trying to explain to the court why this witness seemed shaky without conceding that her testimony is unreliable. It's a subtle repair move. Instead of fighting every inconsistency head-on, the attorney pivots to the human side of testimony: pressure, discomfort, fear, exhaustion. And honestly, that can be effective because a witness who appears overwhelmed may come across very differently than a witness who appears evasive.
fine. Thank you. Nothing further on.
And Madison, welcome to my life. All right. Okay. You may step down.
Your Honor, well, I guess it's not my witness. I shouldn't. I guess can she be excused, Your Honor?
Yes, yeah, I don't have any further questions.
This witness is excused. Okay. Before you call your next one, I have to try to be fair to everybody. I did
Absolutely.
this that way. Mr. Killawall, you have someplace that you have to be, correct?
Judge Kunke?
Judges are patient, no way. Yeah.
What if I said the president?
What?
What if I said the president of the United States?
And you're definitely gonna wait. Let's take Mr. Burns back. I'm gonna try to get one more out and something short. Get folks moving and then we'll call it back up. Okay.
He's going to see that.
And that closing exchange tells you a lot about the atmosphere in this courtroom. The judge is trying to keep the train on the tracks, move witnesses efficiently, and stop the proceeding from collapsing under its own weight. But beneath the scheduling jokes and courtroom banter, this testimony left behind some very real fault lines: memory issues, objections over scope, questions about prior statements, and a defense clearly pushing to introduce a different narrative of the relationship. In other words, this wasn't just a witness recall, it was a fight over control of the story. Who gets to define what happened, which details matter, and whether the witness's uncertainty helps or hurts the case. And that's why moments like this matter so much. Not every dramatic courtroom turning point comes from a smoking gun. Sometimes it comes from hesitation, omissions, and the way lawyers try to weaponize both.